Welcome to NIPT's Decisions on the Go, using AI for over a decade to help you listen to New York State Court of Appeals decisions on the go. After the podcast, visit www.nipt.com/law to read the full decision.
People v. Eric Guerrero, decided February 17, 2026. Troutman. Defendant, 4 months shy of his 18th birthday, participated in a premeditated, armed home invasion, the latest transgression in a pattern of escalating criminal behavior for which he had been receiving services in family court for approximately 5 years. The grand jury jointly indicted defendant and his accomplices on 2 counts of burglary in the first degree, Penal Law Section 140.3023, and 1 count of robbery in the first degree, Penal Law Section 160.153. Under the state's Raise the Age legislation, L. 2017, Ch. 59, Pete WWW, S. 1A, defendant's prosecution was presumptively removable from the youth part of county court to family court, see CPL 722.23. The sole question before us is whether the youth part abused its discretion, as a matter of law, in granting the people's motion to prevent removal. Because the court did not abuse its discretion in reaching that determination, we affirm. After defendant's arraignment, the people moved to prevent removal on the ground that extraordinary circumstances existed that should prevent transfer to family court. See CPL 722.23 1A-D. Specifically, the people asserted that the facts and circumstances of this premeditated attack were frightening and extraordinary and bespoke a level of criminal liability inappropriate for adjudication in family court. They argued that police reports provided to the court demonstrated the existence of such circumstances and asserted that in February 2021, defendant and his accomplices, each with a knife and one with a handgun, planned to break into the victim's home to rob him and then did so, whereupon they displayed their weapons, seized the victim, and threatened to stab him. One accomplice took the victim's shotgun and struck him with it 3 times, causing physical injury. Defendant opposed the motion, asserting that he was diagnosed with bipolar disorder, schizophrenia, attention deficit hyperactivity disorder, and oppositional defiant disorder, conditions for which he was prescribed medication and received weekly therapy. The court convened a hearing where a probation officer testified that between May 2016 and January 2021, defendant received 8 family court appearance tickets and 2 adjudications resulting in terms of supervision. Defendant maxed out the first term of supervision in November 2017, and the second term expired by the time he was released from a juvenile detention facility in September 2020. Most recently, defendant received an appearance ticket in January 2021 for unauthorized use of a motor vehicle. Since 2016, he had been receiving several family court services, each of which the probation officer identified by name. However, the last time defendant appeared in the youth part prior to this incident, his mother declined services on his behalf. The people argued that defendant had engaged in an escalating pattern of criminal behavior despite having received family court services for the past 5 years. Defendant argued that it was important that he continued to receive services through family court because he needed those services to treat his mental health diagnoses. The court granted the motion. Although the court found that defendant and his accomplices entered the victim's home with the intent to commit a robbery and, during the course of the robbery, struck the victim several times in the face with a shotgun, the court noted further that the violent nature of the alleged crimes was not by itself a basis for preventing removal on the ground of extraordinary circumstances. Rather, the court opined that it was also required to consider whether defendant was amenable to family court services. In that regard, the court found that defendant had several mental health diagnoses, but at the same time had been receiving services for 5 years. Based on those considerations, the court concluded that the people had demonstrated extraordinary circumstances sufficient for the case to remain in the youth part. The matter proceeded to a jury trial where defendant was convicted, and he was thereafter sentenced to a state prison term. The appellate division affirmed on the basis that defendant participated in a violent home invasion involving weapons and injuries to the victim, and that, despite the family court services provided to him over the 5 years of his involvement with the criminal justice system, he made no appreciable positive response and continues to engage in escalating criminal behavior. Thus, the appellate division concluded that, under the totality of the circumstances and taking into account the mitigating factors and the substantial aggravating factors, the court did not abuse its discretion in determining that extraordinary circumstances exist warranting that this case remain in the youth part. One dissenting justice concluded that the court abused its discretion. Relying on select remarks by the sponsor of the Raise the Age legislation during the Assembly floor debate, the dissenting justice opined that the legislature intended for the extraordinary circumstances exception to establish a high standard not satisfied here. The dissenting justice granted leave to appeal. Under the Raise the Age legislation, cases involving adolescent offenders, defined in effect as persons charged with committing a felony at 16 or 17 years old, see CPL 1.2044, are presumptively removed from the newly created youth part of Superior Court to Family Court, see CPL 722.10, 1, CPL 722.12, 1 through 2. Where, however, a defendant is charged with a violent felony as defined in Penal Law Section 70.02, the youth part retains the case upon a determination that the defendant I caused significant physical injury to a person other than a participant in the offense, 2. Displayed a firearm, shotgun, rifle, or deadly weapon in furtherance of the offense, or 3. Engaged in certain unlawful sexual conduct, CPL 722.12, 2, C. Otherwise, the case is removed to family court unless, upon a motion by the people, the youth part determines that extraordinary circumstances exist that should prevent the transfer of the action to family court, CPL 722.12, 1D. Preliminarily, defendant failed to preserve his contention that the court erred in considering the totality of the circumstances and was instead required to engage in a two-part inquiry, the first part of which is satisfied only if highly unusual and heinous facts are proven and there is a strong proof that the young person is not amenable or would not benefit in any way from the heightened services in the family court, People v. TP. Defendant did not argue for the application of such a test before the youth part. Instead, he urged the court to deny the motion upon consideration of the totality of the circumstances. Defendant also failed to preserve his challenge under Family Court Act Section 381.2 to the admissibility of evidence related to prior proceedings in family court, cf. People v. Dukes. Defendant failed to object to the admission of the probation officer's testimony and indeed failed to object to or otherwise dispute any of the people's evidence. Furthermore, unlike our dissenting colleagues who make repeated reference to the transcript of the subsequent trial, we reject the party's invitation to consider evidence that was not before the court when it decided the motion. The only question before us is whether the youth part, considering the totality of the facts and circumstances before it, abused its discretion as a matter of law in determining that extraordinary circumstances existed that should prevent removal to family court. See CPL 722.23 1D. The statute does not define extraordinary circumstances, in contrast to other statutes where the legislature has provided explicit guidance about what constitutes extraordinary circumstances in other contexts. See Domestic Relations Law, Section 72(2). Matter of Suarez v. Williams. See also former CPL 65.20, People v. Cintron. The absence of such guidance evinces a legislative intent to leave the extraordinary circumstances determination within the broad discretion of the court. That intent is confirmed by remarks of the legislation's sponsor during the Assembly floor debate. In answering questions about the meaning of extraordinary circumstances, he repeatedly emphasized the importance of judicial discretion and need for individualized determinations, explaining that the judge is to have ultimate discretion and must look at all the circumstances of the case as well as the circumstances of the young defendant. NY Assembly Debate on 2017 NY Assembly Bill A3009C, April 8, 2017, hereafter debate at 2139. That every case is going to be looked at by the judge individually to determine what kind of factors, both aggravating and mitigating, there are in the case, to determine whether or not extraordinary circumstances exist, and that the extraordinary circumstances standard is to be determined and shaped by a judge's ruling. Debate at 83-84. The circumstances of this case could fairly be described as extraordinary. Defendant was no stranger to the criminal justice system. Since age 13, he had been arrested repeatedly, was frequently in family court, and had received many services over a period of 5 years that were intended to assist him in leading a law-abiding life. It is undisputed that, despite those services, his criminal behavior escalated to the point that only a month after receiving a family court appearance ticket for unauthorized use of a motor vehicle, he participated in a pre-planned home invasion in which he displayed a knife and where his accomplice's conduct in displaying firearms would have mandated retention of the case by the youth part if defendant had done so himself. See CPL 722.23-2 To be sure, defendant's mental health is a substantial mitigating factor, and the alternative conclusion would not have been unreasonable. That is, the court could have found it appropriate for the case to be removed so defendant could continue to receive family court services. But we cannot say that the court, after weighing the considerable aggravating and mitigating factors here, abused its discretion as a matter of law in determining that extraordinary circumstances exist that should prevent removal to family court. Contrary to the dissent's concern, our decision today does not treat reoffense in and of itself as extraordinary. This is not a case of mere reoffense, but of chronic, repeated reoffense and escalating criminal behavior. By the time of the hearing, defendant's history far exceeded 1 or 2 youthful transgressions. Moreover, the crime here is deeply troubling. We do not agree with the dissent that a robbery home invasion is a typical youth crime, nor that the salient facts here could readily describe any burglary, robbery, or other violent felony. In the floor debate, the bill's sponsor provided an example of a far less serious burglary, where a bunch of young kids who happened on a porch see that there's nobody in the house and they decide to have a party inside. Debate at 22. In that case, an intent to commit a crime inside the house, other than the trespass, e.g. criminal mischief, could elevate the trespass to burglary in the second degree, a violent felony. See Penal Law Section 70.02 sub 1b, 140.25 sub 2, 145.0 sub 1, People v. Lewis. Such a case, said the sponsor, could go to family court if nobody had a gun or a knife or a weapon or used it. Debate at 22. That example does not describe the only type of case that should go to family court, nor do the more serious counterexamples mentioned by the dissent, where a defendant targets an elderly victim or acts as a ringleader, describe the only types of cases that should remain in superior court. Most cases, like this one, fall somewhere in the middle and thus are properly subject to judicial discretion. The dissent's opinion to the contrary would largely remove from these determinations any judicial discretion, a feature the legislation's drafters believed was crucial to the statute's proper functioning. Accordingly, the order of the Appellate Division should be affirmed. Order affirmed. Opinion by Judge Troutman. Judges Garcia, Singas, and Canataro concur. Judge Holligan dissents in an opinion in which Chief Judge Wilson and Judge Rivera concur. Decided February 17, 2026.
Welcome to NIPT's Decisions on the Go, using AI for over a decade to help you listen to New York State Court of Appeals decisions on the go. After the podcast, visit www.nipt.com/law to read the full decision.